Yes, Your Honor. Good morning. Thank you. May it please the Court, Mark Boykin appearing for the petitioners before the trial court, the respondents in the Court of Appeal, and the petitioners for review in this matter. Your Honors, I believe that this case is a microcosm of why the legislature revoked the statutory scheme under former probate code section 21300 and enacted the 21310 et sec scheme because of the conflicting decisions from the courts of appeal about these no contest clauses. We have seen the various districts and indeed the divisions within the second district come to very different decisions based on, apparently, I would assume, the facts of the individual situation, although the trial court is called upon to make these decisions about whether a proposed claim would violate a no contest clause in the trust instrument based on the allegations of the pleading, at which point no facts have been proven.
So let me just ask this, Mr. Boykin. There are two no contest clauses, one in the Second Amendment, one in the original, I want to call it the first family trust instrument.
Yes, Your Honor.
Why is it here that the beneficiaries' challenges or use of the safe harbor petition and or the challenges that they make here to the Second Amendment violate or do not violate the no contest clauses?
I don't believe they violate the no contest clause, Your Honor, the principles espoused in Bradley versus Gilbert. Those clauses cannot be used to insulate a trustee from claims of breach of fiduciary conduct or a challenge to an accounting.
Well, let's put aside the petitioner's claim is broad, or the beneficiary's claim is broad, a number of challenges, not only against fiduciary misfeasance and accounting, et cetera, but also some claims as to the Second Amendment and the allocation distribution. Why, focusing solely on the allocation distribution, not the fiduciary issue, unless you want to talk about the fiduciary responsibility. Why isn't it correct, as the Court of Appeal found, that the beneficiary's challenge was a challenge to the instrument in violation of the no contest clause if pursued?
Yes, Your Honor. The trust, as is typical of these exemption equivalent trusts, created a two-tiered system of distribution. At the first death, in this case the husband, the trust was to be divided into two trusts, the decedent's trust and the survivor's trust. The wife had access to the assets of the decedent's trust on a limited basis to maintain her standard of living for the rest of her life. But at her death, that decedent's trust had to be distributed in the manner in which it stood at the death of the decedent. So in this case, what happened was when the husband died, the trust said that at the second death, the entire trust shall be distributed to all of the children, living children of the of both spouses, pro rata. Now the decedent, the survivor, after the death of the decedent, amended the trust to make the distributions of her portion discretionary. It is a matter of federal tax law, I believe the law of this state, and as addressed in the case of McIndoe, that the survivor had no power to change the distribution of the decedent's trust, that the decedent's trust had to be distributed in the manner in which the trust stood at the death of the decedent. The Court of Appeal turned that on its head, in effect, and said that the survivor retained the power to control the distribution of the decedent's trust and could amend or revoke it. I believe that that holding by the Court of Appeal is wrong as a matter of law and as a matter of the terms of the trust agreement that's in effect. So I do not believe that the beneficiaries seeking to receive the distribution that their father provided for them is a challenge to the Second Amendment. The Court of Appeal disagreed with that position.
Were there, in effect, two distribution provisions conflicting with one another after the amendment was made?
I don't believe there's a conflict, Your Honor. I believe that the survivor, as was her right, wanted to see the trust distributed in a manner different than her husband, who had predeceased 2 years earlier. She had that right to change the distribution of her portion until her death, and that's why we have not challenged that action. We are only challenging the failure of the trustees to distribute the decedent's portion, which we believe the law and the trust agreement require to be distributed at the second death.
Well, would it be fair to say that the Second Amendment created by Mary Donkin prior to her death was vague because it didn't mention the first, in its amendment and its new allocation that you say is of her survivor's trust. What it doesn't do is actually specify what she's amending. It appears to be amending the entire family trust and all of the assets distribution. So there's an ambiguity in the Second Amendment, would you say, that is requiring of interpretation as to what she intended to distribute. And you're saying she couldn't have intended to distribute marital decedents' trusts B and C because she had no authority to do so.
That is correct. And she incorporated the trust document by reference in that amendment. So therefore, if she says, I'm amending the trust, and the trust says you cannot amend the decedent's portions, how could she be amended? I'm sorry?
There's a conflict, as Justice Baxter has referred to.
Well, again, I believe, 30 years of experience in preparing and administering trusts, I believe, and I think the federal law is very clear, that the rights of the survivor to the decedent's portion are very limited. 5% invasion of principal for no reason at all, unlimited invasion for support and maintenance, plus net income. That does not include the right to amend the provisions of the decedent's trust. The trustees in this case have taken the position that the decedent's trust qualified under federal tax law to be exempt from taxation at the first death. So they have recognized the fact that this trust was meant to comply with the provisions of the Internal Revenue Code, sections 2001 and SEC, with regard to the rights of the surviving spouse. The right to amend the trust or to alter the distribution is not included in those provisions.
Let me ask you, why then, as you phrased your argument, I assume the opposing counsel would ask this, as you phrase the argument, why aren't you in violation of Probate Code section 21311 subdivision 2 that says a no contest clause shall only be enforced against a pleading to challenge a transfer of property on the grounds that it was not the transferor's property at the time of the transfer, etc.?
Well, as I indicated, if she says I'm amending the trust and she's invoking and she's including by reference the trust document which says you do not have power to amend the distribution of the decedent's portions, I think as a matter of law, that amendment must be limited only to the portions over which she had the power to amend.
If you can help me out, is it correct to say that here we have what I would refer to as the former law and the current law? And if my memory serves me right, under the former law, that former law had the provision pertaining to a so-called safe harbor provision, right, so far?
Yes.
And if memory serves me correctly, it seems that under the old law, there were certain public policy creations or provisions. Under the new law, no public policy stuff. And here, the trial court, did it apply the old law because when the petition in question was filed, the new law hadn't taken effect yet?
That is correct.
And what is your concern or your problem with the Court of Appeal? The trial court ruled in your favor, right?
Yes, it did.
And the Court of Appeal disagreed with the trial court, and obviously you're here because you disagree with what the Court of Appeal did. I wonder, could you just succinctly point out to the court where the Court of Appeal went wrong, in your view?
Okay.